Dear Heavenly Precious Father, we thank you for the opportunity to join each other here again today as the commission. God, we just pray that we're able to find resolution to problems, make things better for the citizens of this county, and leave this county better off than where we found it. In your holy and precious name we do pray. Amen.
Amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Hey, good morning, everyone. Call this regularly scheduled meeting of the Nicholas County Commission to order. Today is Wednesday, July 10th, 2024, and it is 9:11 a.m.
Recording in progress.
Okay, we're going to call this meeting to order. Today is Wednesday, July 10th, 2024. That being said, do we have anyone for our public comment period? Okay, that being said, if we could go through the motions, please.
I'll make a motion we review and waive the reading of the June 26th, 2024 minutes.
The motion's on the floor. Is there any discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Aye. All those against? The motion does carry.
Upon review of the exonerations as presented by the Nicholas County Assessor, move to approve accordingly.
That motion is on the floor. Is there any discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Aye. All those against? The motion does carry.
Upon review of the estate and fiduciary matters as presented by the Nicholas County Clerk, move to approve accordingly unless otherwise noted.
That motion is on the floor. Is there any discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Aye. All those against? The motion does carry.
Upon
Take
submission of budget
turns.
revisions received from elected officials and department heads, the commission will take appropriate action as deemed necessary.
That motion's on the floor. Is there any discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Aye. All those against? The motion does carry.
Upon review of the invoices as submitted by the various departmental offices, the commission will take appropriate action as deemed necessary.
Okay, that motion's on the floor. Is there any discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Aye. All those against? The motion does carry. For terms of office expiring, we have the Nicholas County Solid Waste Authority, Fred Monette, with a term of office expiring June 30th of 2024 for a 4-year term. So we do need to have a reappointment or replacement for a term of office expiring June 30th of 2028.
Mr. Monette had trouble getting to the meeting, so we would like to replace him with Chris Moore from Cherry District.
Okay, that motion's on the floor. Is there any discussion? Any other motions? Hearing none, all those in favor signify by saying aye.
Aye.
Aye. All those against? The motion does carry. For the New River Gorge Regional Economic Development Authority, my apologies, Elizabeth Dix, with a term of office expiring June 30th of 2024 for a 3-year term. This will be for a term of office expiring June 30th of 2027.
Elizabeth is extremely busy with her business, and she said if we can find someone, she would be glad to step off. So, we'll make a motion to put on Anita Gross for this position.
Okay, any discussion? Any other nominations? Hearing none, all those in favor signify by saying aye.
Aye.
Aye. All those against, the motion does carry. We have some small stuff to go over. We'll put that at the end here because we're a little bit behind. If we could now, we will go to the estate of Dennis Naylor, file number 10575, concerning an objection to final settlement. You do have a packet prepared for you by the clerk's office in front of each commissioner. That being said, everyone that is here for that estate, if you'd raise your hand, please. And if you'd state your name for the record, and Patty will take your names down. You'll just kind of tell her as you do. Oh, you already have. See, she's on it. That being said, everybody that wishes to speak, excluding legal counsel, anyone that wishes to speak on this, if you please raise your right hand and keep it up. If you have any intention to speak whatsoever, and keep your hand up. Do you and each of you solemnly swear or affirm that in the matter now in hearing, your testimony will be the truth, the whole truth, and nothing but the truth, so help you God? Very good. If you could kind of brief us on where we're at.
Okay, so this matter was last heard before the commission on February 7th, 2024.
Attorney James Mullin was seeking relief for his client Connie Naylor by asking for the removal of the executor due to inaction. The executor filed an appraisement of the estate on February the 2nd, which you have a copy of. The executor at the time was unable to file a complete appraisement due to the fact that they did not have access, that he did not have access to the property. So he went from what he knew of what the deceased owned as far as personal property at the time of his death. At the February 7th hearing, County Attorney Tucker recommended that Mr. Milam and his client work together to come up with a time that the executor could gain access to the property to do a more accurate and complete appraisal. On April the 5th, the executor came into our office. There had not been any arrangements made as to access the property, to complete this appraisal. I advise us to go ahead with the final settlement as they wish to get it closed, because of course objections can be made within 10 days to the final settlement. That did happen on April 10th. Our office received an objection to the accounting of the estate. If you'll notice from the appraisal to the copy of the final settlement that you have there, the amount of personal property that is contained in the appraisal was moved over to the final settlement, and it shows, according to the will, any properties go to the nephew, the executor, who is David Clutter, and $5 was to Connie Naylor. That is reflected on the appraisal, or I'm sorry, on the final settlement. So in order to determine the exact objection, I'm not for sure what the exact objection to the accounting is, as what was on the appraisal is what is on the final settlement. So that matches up. And as far as what the will stated, that also matches up, as in all property went to Mr. Clutter, and that Ms. Naylor received $5. So, but hopefully Attorney Miley can explain more what the exact objection is. Your time.
Good morning. Under the statutes, my client has the option to take an elective share from the estate. They were married 9.5 years, and I believe that entitles her to 27% of the estate, and she is electing to do that. This is a complicated estate. There's property, the home itself is titled in both Mr. Naylor and Mrs. Naylor's name. The property, I believe, is on the land of Mr. Naylor's father. It's still in his name. This is a very complicated estate, and it can't just be assigned as they've proposed. We're asking, and I don't mean to cause anybody expenses, but really, they need to get a lawyer involved on the executor side to determine the exact distribution in this estate. And I'm not sure what their plans are with the home, and nobody's ever called or anything, what the plans are with the home or the property or any of those things. So we filed the objection on that basis.
Is it a mobile home?
Yes.
Is there a title to the mobile home?
Yes.
Do you know how it's titled?
Both are named. I have it with me.
Then that survivorship in that home would belong to
Right.
the wife.
So as far as the property itself goes, the real property, that might be out of the jurisdiction of this matter if it's still in the grandfather's.
Is he alive?
Is not.
Did he have a will?
Grandfather? I'm not sure.
So if he died,
I'm sure he did.
well, it'd have to be determined how the property went when he passed. If the decedent received a share of that property and she's electing, she has statutory right to an elective share, she would receive her percentage of that, his percentage of that property.
What was your grandfather's name?
Howard Morgan Naylor, Sr.
Should we have to check on that?
I can check it.
How much is Ray? In the meantime, do you all have anything you'd like to add while we?
I'd just like to say, as far as legal representation goes, times are tight. We have looked into getting an attorney, but it's just it's impossible for us at the current time. He's planning on actually moving on to the property. We served eviction notices that have gone unheeded. Actually, we were waiting for this hearing to move forth with the actual removal. We've done everything that we possibly can by the book as far as we know.
Well, did Howard Morgan Naylor live in this county when he passed?
He lived on the well, he didn't live on that property. He had moved from the property to Craigsville, but yes, he
He was
lived
still
in
in
the
this
county,
county,
yes.
right? So if he had an estate, it would be filed here.
Where's the property located?
It's 24 Alamo Drive on Nile Road. And as far as the 6% or whatever it was, out of everything that was listed on there, nothing's there now. It's all been sold off or removed or something.
Everything right down to there were 9 buildings on the property. There were 2 entire buildings missing.
Not the
No.
contents, the entire buildings.
How many acres is the property?
1.7.
1.59.
Who's this?
I'm white.
No, I'm sorry. I'm so sorry. Who's on Zoom? I not mean that towards you.
Screen behind you. Up there.
Okay.
I thought he was getting a little bolder.
Yeah.
I skipped breakfast.
New baby.
Yeah, right. I can't find the property or a deed or a will.
I
Did he have
think
an estate?
Let me.
Huh?
Did he have an estate?
I can't even find an estate appraisement or anything on here, so I'm not real sure. Howard Morgan Naylor.
senior.
Yeah, there's no way to do senior here. There's a few things on junior, but not.
I've got the deed transfer. I think it's the deed transfer from my grandfather to my uncle right here.
Really?
If you'd like to see
What's
it.
the
So
book
it-
and page?
it
In that
didn't
little
go-
square in the bottom right? What's it?
Book 478, page 772-773.
So it was deeded to
My uncle,
by your grandfather?
yes.
So,
Prior to death,
okay, so the estate wouldn't matter. Was it just in your uncle's name?
yes.
Is it dated?
2013.
Were you married then?
Ma'am.
Pardon?
Were you married in March of 2013?
I don't, to who?
Yes.
I don't think so. Was I married again? I don't think so.
You got married in October.
I got married in October 5th. I don't know what you was. And I didn't get
It comes from. Sure did.
Did your grandfather pass away in 2014?
I believe so, yes.
It doesn't matter now that there was a deed from the
It was
grandfather.
pre-deeded, so the estate was moved.
Oh, okay. I found the estate now. But I guess it.
Yeah, he just showed that. So what would happen is the real estate, if she has claimed an elective share, the real estate is part of that estate. You have to determine, it gets complicated, what's the augmented estate. She's entitled to a statutory share based upon the length of the marriage of that augmented estate. I'm not sure you have enough information at this point to do that.
Well, would her share not come out of the real property that has been sold, transferred, squandered, removed?
We were told not to remove anything at all from the property, and to the best of my knowledge, everything that was there is not there anymore.
There was.
Well, whatever the augmented estate is, she's entitled to 27, what was that percentage? 27%. That's statutory. That's the The widow has the right to elect against the will.
In your question, let's just say that number is $50,000 and $50,000 worth of stuff is now gone. Does that cancel it out? I think is what they're asking. That's
Right, there's that much or more.
Right.
There was quite a bit of personal property that's. Yeah,
Well, I mean, it just depends on who took it
understood.
and a lot of factors.
Right.
Well, we,
Proving that where everything went. Understood.
Right, the 1.59 acres that we have listed on the appraisal, and I believe that is the property that we were speaking of, correct? Okay, in 2013, Howard M. Naylor conveyed that property to himself, and Dennis E. Naylor was raised to survivorship. So upon Howard Naylor's death, it would have became Dennis Naylor's property. I did find an estate, Howard M. Naylor. I don't know which is junior and senior, but there were two in there. So this property would have conveyed through survivorship, not the estate, it would have been a non-probate asset. And Howard passed.
It's going to require evidence in a hearing. And there is no fiduciary commission. That's a question.
No, there's not. Unless,
Huh?
We might be able to find some.
That's about all you can do, unless you all want to hear it.
Well, yeah, that's what I'm thinking. You're judge too. I'm gonna put Gary as chief judge of that, Gary.
Let's get a gavel.
didn't mean to hit her.
I mean, that's what, unless,
I mean-
again, unless you all want to, I would refer it.
Would be your recommendation? Try to refer fiduciary.
I think you
first.
probably ought to send it to a fiduciary commission. I mean, rules of evidence apply.
Do we give a month to try and find one? Because we don't want to hold everybody up for 6 months
Well,
waiting.
you can reset it on your agenda for whatever time period you feel is appropriate to find one.
Because then now if we agree to send it to a fiduciary, then we have to bring it back to approve the fiduciary?
No, just make the referral and then set it for whatever hearing you want to set. The next hearing date, if they've had it before a fiduciary commission at that time, you just don't do anything.
Okay.
I have a question. You know, you got a pretty good list here of items with the tools and things like that. You say it's all gone?
Everything.
Last time I was in the garage used to be so full that whenever I walked in one door, I couldn't have possibly walked to the other side of the garage without going completely around everything. Last time I was there, I walked in the double doors and I could walk directly in any direction I wanted to and never offered a trip on something.
2 wheelbarrows full of trash laying in the middle of the floor roughly. Right down to the car lift.
So that means in the garage alone, the car lift is gone, probably 15 actual roll around, like dual stack
Can you hold on for a
toolboxes.
second? Will you swear them in and her?
You already have?
You already did?
Yes.
Just wanna make sure.
The property
Oh, yes.
apparently went to a Johnson down Route 39 who is apparently deceased recently. That sounds right, but I'm not sure. That's hearsay that's come to us through friends.
Greg, the second
That he
weekend.
has the stuff.
The second
He
weekend
had,
of August.
it was at his place.
His son David would have it, probably, which is a good guy, an honest guy.
Maybe, I don't know. I don't know the fella. I'm just repeating what's been told to me.
Okay, so the question to you, where's all this stuff?
They took it.
Ma'am, you didn't get sworn.
I sold it, but.
Wait a second, swear.
If you'd like to speak, I can still swear you in.
Or they both raised their hands.
Yeah.
I only saw you. Okay. Do you, keep your hand up, please. Do you solemnly swear or affirm that the matter now in hearing, your testimony will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Okay.
So you sold all this stuff?
It was marital property. Well, I traded it to get me over here.
So you traded $260,000?
No, sir, that was not. There's nothing there worth that ever. Has never been that.
So who did you trade it to?
To James Johnson. And he recently passed in February.
And And as far as appraisal goes, we didn't look at what it was valued at the time. We couldn't because it wasn't there.
I do have a
We had to
picture.
go by what it was gonna cost to replace
I've got a picture of one welder that whenever I looked the numbers up on it was $47,000.
for one welder to replace it.
And you traded all of this stuff?
No. I sold some of it, and some of it I traded to get me a lawnmower. I had no lawnmower. I had no vehicle.
So you sold and or traded?
Yes,
all
but it
this
was
stuff?
marital property.
But a lot of the tools were in the garage when my uncle received it from my grandfather.
They're still there.
So,
No, they're not.
but you're claiming 26%?
27, under the elective share.
So where's the other 74%?
It's still there, or they took it.
We didn't take anything.
Every
We
time-
couldn't. Every time we was down there, the law was called
And they
and
never did show up.
false allegations was told about how we were, how he was violating
She would call the law and tell them that she
DVP.
had a PPO against me, a personal protective order.
That happened several
And
times that I was
that was not the case. There was no
Yeah,
protective
talk one
order.
at a time.
There was no protective order put in motion, and that's what she was telling the law in order to get them down there trying to get me arrested for false allegations.
So the
I told you
27%
that.
would be of the house and the land?
Whatever, well,
It'd be 27% of the total.
Okay.
yeah. There's a formula to determine what she's entitled to 27% of.
Gotcha.
But now the house itself, since it was in both their names, is the
Exactly.
house hers,
Yeah.
period? So you kind of take that out of the equation. and
Yeah,
divide
that's
it.
not part, I would, well, it's been a while since I've looked at that statute. It may include some survivorship property.
Do you have a list, and would you be able to prove what you sold or traded?
Yes. And the stuff that they put down on there, they took some of it. And the rollback, it was my husband was a diesel mechanic, and the individual came back and got his rollback. Randy Smith, and the welder, he came back and got it. It was his. Adam Bostic had two pieces of equipment down there, he came back and got it. It's his, I can't keep it. I mean, I cannot keep it, it's there.
As far as Adam Boston goes, there was also a motor, an engine to a Bobcat in the corner of the garage that also apparently went to the scrap. Because when Adam showed up and met us to get his engine and some of his other things back, they were gone.
He was talking over $20,000 worth of
Just
parts
his
and
own
tools
personal things.
that was missing.
So who was the person that got the other rollback and what?
We don't
There was a
know.
rollback, that belonged to Randy Smith.
One of them did.
Then there was
My
another
uncle
one.
was building another.
That was mine. We got it after we got married, and I sold it.
But you only were entitled to 27% of it. So where's the other 74%, 73%?
It's still there. They're talking about a
Out
hard.
of what you sold, is what I'm asking. If you sold something, apparently you were only entitled to 27% of the money. So where's the other 73% of the money?
I didn't get that much money out of anything. I traded.
Your Honor, we haven't even been able to pay the debt for the
Please
burial.
don't call me Your Honor.
Sir, we haven't even been able to pay the debt for the burial. My family stepped up and paid that. When she was contacted about the burial, she said, I don't want no part of it.
And then
Didn't show to the wedding, or to the funeral or the wake or
Should
anything.
at least have that interest.
I mean, we've had no help. We've tried to do this on our own, and
And
I
meanwhile,
believe
she
my
won't even let us
recommendation would be that excuse me.
oh, sorry.
It'd be my recommendation, we refer this to a fiduciary, and we'll set an agenda item for August 21st. If that's not completed by then, this commission can hear this out. Is that okay with you? Does that make sense, legal counsel? That motion's on the floor. Is there any further discussion? Hearing none, all those in favor signify by saying aye. Aye. All those against, the motion does carry. And hopefully the fiduciary can help everybody put this to bed and keep moving on. Okay, and if not, no, you're fine, you're fine. We're behind schedule and we just need to keep moving. But that being said, hopefully the fiduciary can handle it, or we'll come back
Is there anything
and
we
see
can-
what we can do.
Is there anything we can say, a motion to, nothing else can be sold until this is settled?
You can order that no further assets be transferred until the matter is heard. And and conclude it. If there's anything.
I would like to make a motion that we make an order as of this court that no other assets are sold or removed from the property until this is settled.
That motion's on the floor. Is there any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
All those against, the motion does carry. So put everything in order and let you all get a little time to get together.
Can we ask one question? Are we allowed on the property? Because we haven't tried to go down because the gate stays locked and it's been a real nuisance.
I'll be honest with you, we are the judges of this, but we're not the lawyers of this, so I'm not real sure.
He's the.
But he is the executor.
As the executor, he would have certain rights to do that.
Are you wanting to come and get stuff or just look around or what do you
We're
want?
actually looking to move things down there and hoping, with hopes of not watching them walk away.
My toolbox and stuff like that at the garage, and I'd like to move them down there in the garage without my stuff disappearing.
Me personally, I wouldn't move anything anywhere.
I wouldn't move anything.
I mean that both directions.
I would use that
Everything
right
stays as
as checking in on things, but not removing nor adding.
Yeah,
to.
I think that order works both ways,
Yep.
for her and for you guys. Until this is settled, please don't.
Don't bring anything in.
Yeah, nothing in or out. That way there's a baseline.
Right, don't complicate things for yourself any more than you have to.
And if it were me, I would probably go down to the sheriff's department and get an officer to go with you and go take an inventory and actually do that. But have a law enforcement officer with you.
Absolutely.
Every time they did come down, they would come to my gate, and I would walk down to unlock it, and they would leave. Every time. You ask my son.
If you guys let me know the date and time you want to do it, we'll make sure you have open access.
Well, the last time we did that we went and we sat at the gate and nobody came down and unlocked it.
And that was after we called you and.
That was after our meeting, you actually.
How far is the, it's only an acre and a half? I mean, the gate's locked, just walk around the gate.
We didn't know if we could legally do that.
Every time I've done something of the sorts, she calls the law and tries to get me in trouble.
Well, you're the executor of the estate, you have that right.
Okay.
You're representing your uncle, actually. So just, is that correct?
Yeah, I actually have a duty to go do that.
But if you'll work with Mr. Milam, he's a good guy. He'll work with you.
Absolutely,
He's not-
absolutely, we will.
All right, everybody wants this to come together, be put to bed, and everybody can move on.
Thank you, guys.
Absolutely. All right, thank you all.
Run this and call.
That being said, Patty, if you could check the hallway for anyone here for the estate of Joe P. Kaufman, please.
Well, I got full staff. I know, but anything you need to get through the week.
Is there anything we need to do?
If you'd like to ask her.
You're good. I mean, as far as our office goes, you're good. You're welcome.
Hello, sir, how are you?
I'm well, thank you.
Good. Mr. Hammond, who are you representing here on this?
I'm representing the executrix Paula Kaufman,
Paula Kaufman, okay. Thank you, sir.
and that's, I believe, her on the Zoom call. I've never met her in person.
Good morning, gentlemen.
Good morning. My name is Garrett Call. I'm the president of the county commission. Could you state your name for the record, please?
My name is Paula Gisette Kaufman.
Okay. You got anybody else in the hallway? You don't mind, check, please. How are you doing, sir?
Doing well, how are you?
Good. Which one?
Hi, I'm David.
Oh, Jacob Shook, nice to
Hey,
meet you.
Jacob, nice to see you.
And Mr. Shuck, who are you representing?
The petitioner, Laura Gabriel.
And is Miss Gabriel going to be here with us or
No,
by
sir.
Zoom?
No, sir.
Okay. Okay. So as far as we know, everybody's here that
That's correct.
we're to expect. Okay. Ms. Kaufman, our friends of the legal community here don't need to, but I'm going to ask you if you could raise your right hand, please, and I'm just going to swear you in to be able to discuss this matter, and then we'll get started. Do you solemnly swear or affirm that in the matter now in hearing, your testimony will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
very much. Thank you very much. So that being said, that is Paula Kaufman, who is the executrix of this file. This is the estate of Joe Kaufman, file number 10693. And this is regarding a request for removal of the executrix. We do have Mr. David Hammond, who is representing Ms. Kaufman. We also have Jacob Shuck, who is representing Laura Gabriel, who is the beneficiary. And is she the one raising the objection?
Yes.
Okay. That being said, if you could brief us real quick and we'll get started.
All right, so in your packets there, again, you have the will. This estate does, this test state, so it does contain a will. There's also an appraisement in there for you to review. So on May 13, 2024, our office received an objection to the estate by one of its heirs, Laura Gabriel, by her attorney, Jacob Shuck. The objection requests the removal of the executrix, Paula J. Kaufman, and that Laura Gabriel be appointed as the administratrix. Concerns that were stated in the petition, which you also have there in your packet, is the executrix's failure to communicate furnished information, and that the executrix intentionally omitted assets from the appraisement and did not file the 6.02, also known as the non-probate inventory. Since this objection, we've also received from counsel Jacob Shuck some subpoenas that require Truist Bank to release documentation pertaining to bank records of Joe Kaufman, so he may have some more information on that. And then also, I just gave you a little rundown of the people in this estate so that you would know who is who. Okay?
Absolutely, thank you. So that being said, Mr. Shuck, if you'd like to begin with the explanation of your objection, of your client.
Yeah, sure. So actually, we'd like to ask the county commission to just hold our petition to remove executrix in advance. Yesterday evening, we got an updated non-probate inventory containing the accounts that we were concerned about. And it looks like everything's there, but we haven't had the chance to thoroughly review it. So we'd like to keep this petition before the county commission, though, to make sure that the executrix follows through with what she's required to do, but there's no reason now to hear it. We would like to hold it in abeyance and maybe schedule it for 60 days down the road just to make sure that she follows through. But we've been working with Mr. Hammond, and he's provided what we've asked. It appears that he's provided what we've asked for. So.
Okay, Mr. Hammond.
Thank you. I did not become involved in this matter until the petition to remove Ms. Kaufman as executrix had been filed. So at that point, after consulting with her and doing a fair bit of diligence to try to round up the missing information, I have prepared now, actually we're on our second draft of a revised and amended appraisement, which I have a copy of here. It is correct, and I am willing to stipulate that when the original appraisement was filed, the Part 6.02 to the appraisement, the inventory of non-probate assets was not included. That was due to the fact that my client, I think, misunderstood what was required of her in the course of this. In her defense, she is a resident of the state of Missouri and was trying to do this at some distance. After talking to her on multiple times and asking her to provide information, which I have obtained, I did prepare this document, which I have provided to Mr. Hustle, who is Mr. Shuck's partner, regarding the additional non-probate assets. So all of those non-probate assets, as you know, on 6.02 passed to the beneficiary of those assets without actual reflection upon what's in the will. So the primary value in the estate on the probate side, on the 6.01 side, is in Mr. Kaufman's former residence, and that would be a probate asset under the terms of his will. That item has been also amended in this document to adjust the value from what was stated in the original appraisement that was filed by Ms. Kaufman, because subsequent to filing that, she actually entered into a contract to sell it. That contract has now closed and the property is sold. So we determined that, we consider that to be a pretty fair determinant of what market value would be. So the market value of that property has actually gone up pretty significantly, but that is a probate asset, and those funds will be distributed. And in accordance with the terms of the will, all of the net funds that were received, as well as the other probate assets, would be distributed to the 3 beneficiaries, who are the 3 surviving children, well, 3 of the 4 surviving children of Joe Kaufman. The 4th child was, who was not, by the way, the petitioner, Laura Gabriel. The 4th child is not a beneficiary of the estate. But I do have this, if this is something that you would like to see. But I have provided this to Mr. Hussey and Mr. Shutt.
If they're satisfied amongst both parties.
Yeah, I mean, that's not an official document until it's recorded yet, so, I mean, if they're working it out, my suggestion would be to set it 60 days to make sure it doesn't linger. But hopefully everything will be resolved at that.
Is there any objection to 60 days from your side of the?
I have no objection to that.
Okay.
Has it been published?
It has been published based upon the original
Yes.
appraisal, yes.
Yes, it was published.
So I don't think it needs published again.
No,
It's
it will
already
not
been-
be published again.
So actually, once you all agree on the appraisals, if it's already been published and it's been, so the time period for claims creditors has expired, you could probably do a waiver. File so.
The time for claims has actually already expired. It expired July 1st, so.
Yeah. So hopefully you all can have it wrapped up and completed by 60 days.
I'd like to make a request to give this petition on removal an extension in the interest of both parties trying to find resolution in the meantime. And this item be placed back on the agenda for August 21st. Should there be no forward motion, or should we be able to proceed? Either way, it would be on the agenda for August 21st. Motion's on the floor. Is there any further discussion or questions? Hearing none, all those in favor signify by saying aye.
Aye.
Aye. All those against? The motion does carry. Thank you all for coming in.
Thank you, gentlemen.
Thank you.
Yes, ma'am. Thank you. We're running a little bit behind here, but we're joined now by Cassandra Lawson, the Senior Project Specialist at Region 4 Planning and Development Council. This is regarding the Birch River PSD Mill Creek Waterline Extension Project, resolution number 6. And then we have another one after that, but we'll begin with that one if we could.
All right, that sounds good. So as referenced, this is resolution number 6 for the Birch River PSD's Mill Creek project. We have pay estimate number 4 from the construction contractor Pro Contracting, the amount of $21,340.31. We have invoicing from E.L. Robinson for the prior month in the amount of $15,715.38. We missed Region 4 invoice, so we have an invoice from September 2021, and then also February and March of 2024, totaling $2,047.07. Also reimbursement to Region 4 for ordering the checks for the project, as well as paying a fee from the West Virginia DNR for environmental review. Some of those invoices and the reimbursement is $175.05. Then we also have a reimbursement to the Birch River PSD for renewing their DOH bond required for the project. That was in the amount of $1,100. So $24,662.43 is coming from the Community Development Block Grant, and that is the funding which the commission sponsors. $15,715.38 is coming from the Infrastructure Jobs and Development Council. That goes directly to the PSD. And the sum of all of the invoicing combined is $40,377.81.
If you could give us just a quick idea of like where that project is. I mean, are we done with construction? Are we halfway through?
They're pretty close to being done. The PSD had their meeting yesterday, and I'll probably butcher this to some extent. When the contractor was ordering materials, they missed ordering something. I can't remember exactly what it was. It's got a 12-week lead time, so they won't be able to completely wrap everything up until that is received. But whatever that component was, it's not going to prevent them from actually like flushing the lines, testing the lines, and getting the residents, the water service. So they will still be able to hook on. I think The substantial completion date is like August 29th. So between now and the end of August, hopefully folks will be able to actually start connecting to the system. And then it will take a little bit of time for them to like finish their cleanup work, any driveways that were damaged, seeding, and then installing that component.
So these will probably not be the last invoices received in this project?
No, they won't be, yeah.
How many customers is this?
I think 33 altogether. Initially, it was only 18, but then the project had such a significant underrun, they were able to add, you know, so many more. So I think it's 33 altogether, something like that.
Great.
Yeah.
We have a motion to approve the Birch River PSD Mill Creek Waterline Extension Project, Resolution number 6.
Motion.
Motion's on the floor. Is there any further discussion or questions? Anything from legal counsel? Hearing none, all those in favor signify by saying aye. Aye. All those against, the motion does carry. Sometimes you don't always want to hear the lawyer, so it's quick. But that being said, I'm just kidding. We also have the Birch River PSD Mill Creek Waterline Extension Project Grant Amendment number 4.
Okay, so this amendment is actually, it makes no change to the award that the Birch River PSD has been, or the commission has been obligated on behalf of the Birch River PSD. What we're doing here is the development office, they receive funding from HUD each year, and they have some money left over from a 2017 allocation that they're trying to spend. So they're swapping funds between projects in an effort to move that older money out of their system. And so this essentially is a budget amendment of no impact to the project. It just allows the development office to swap funds from project to project internally to try to get some of their older funds spent. So we're kind of just trying to help them out with that.
You have a copy of that, too? Just don't get me wrong, I trust you and I understand you, but I'm just trying to...
So what we're doing, you see the award amount?
Yes.
Is still, that is the original award amount, and it's the same. This is what they're moving. So they're moving it from their 2017 funds. They're swapping.
Yes.
So we're gonna pay this amount, which jives with this invoice from the 2017 money to get it out
Instead
of their
of the
coffers.
2019 money.
Yeah, and then they're
Okay.
gonna move 2019 money to backfill it. So
Okay.
that they're just kind of getting older funds out of their budget.
I think I understand. No, I was kidding. No, yeah, that, thank you for the extra explanation.
It's not very easy to explain.
Are there any other questions or is there a motion concerning Birch River PSD's Mill Creek Waterline Extension Project Grant Amendment number 4? Motion's on the floor. Any discussion? Motion to approve is on the floor. All those in favor signify by saying aye. Aye. All those against, the motion does carry. And we would be the sub-recipient on this, is that correct?
That is correct.
That sticky note over there is the other attorney. Patty explained it, I forgot to tell you.
And I did want to ask, did you all receive the invitation to our upcoming council meeting, Region 4 council meeting, dinner meeting?
I don't think so. Is it like next week?
Yeah.
I'm not sure.
At Charles' office?
No, so we try to hold it in different places around the region. It's like our annual summer picnic. And it will be in Webster Springs at the municipal building. I think it's the Monday after next.
If you wouldn't mind sending us a reminder email on that, because I don't think I saw that.
Yeah, sure. So it's gonna be, it's Tuesday, July the 23rd. And that'll be at the town hall in Addison, Webster Springs.
Yeah, I'll bring you a cake.
What time?
Working
I
birthday.
think 11:30, and then we're
Okay.
gonna eat at noon.
Gotcha.
I'll send you guys the flyer though. What is it?
Ooh.
Consider it a party.
Oh, okay. We'll get someone to bring a cake.
I said I would. It's a working birthday. Patty, if you'd like to make copies for our records.
No, like he's buying a
Thanks.
Thanksgiving cake from Dairy Queen.
Let them melt. I might surprise you. I might surprise you.
That's from
Thank you.
Rather contribute
We're
this
trying to
here.
do the high-tech stuff.
Once a day, buddy.
What confuses me is, like, it gets on the counter from one person to another person, it's the same thing, but it'll say two different, and I get really confused.
I try and watch it. I did, but if somebody's already done it, I don't. But you gotta watch me, because the other day I put the commission meeting for today on there at 2 p.m.
Hey, we'll sleep in.
You guys legit just use my computer.
Right? President phone for the
My leader.
Yep.
President Cole.
Led us astray.
President Martin Cole.
Oh my gosh. Oh my gosh. If we could, let's take a quick recess to get everybody on for this. Mr. Wood, what's your first name for the record?
Henry.
Henry, that's okay. Thank you, sir.
Recording in progress.
Henry.
Yes, sir. Is
Yes,
she coming
sir.
back with a file on this? Okay, we'll get started while we see here. We're here now on the estate of Oscar Tharp, file number 9170. This is regarding follow-up on previous hearing held on April 17th of 2024.
She just said she
We do have appearing before the commission here today, Mr. Jacob Shuck, and you are representing
Connie Tharp, the executrix.
executive. I can never say that. And by Zoom, we have Mr. Henry Wood, who is representing oh no, our internet's a little messed up. Mr. Wood, can you still hear us? I think our internet here at the office is a little slow for some reason.
I can hear.
Okay.
I can hear you very well. Sometimes when your head's down, it kind of gets a little garbled.
Okay.
But Mr. Commissioner, I can hear you very well.
Okay, and Mr. Wood, who are you representing here? Good.
I represent the children of Mr. Tharp, who was Michael Tharp and Linda Willis here today. Also, the estate of Oscar Tharp Jr. The executrix of that, or the executor of that, is also Michael Tharp. Several of the children, or rather grandchildren and great-grandchildren of the estate of Oscar Tharp Sr. The only beneficiaries I don't represent would be Connie Tharp's son and his project. Children, grandchildren on that side.
Okay, thank you, sir. So that being said, thank you all
Yes,
for
sir.
joining us. We're here on the file again of the estate of Oscar Tharp, file number 9170. Anyone that's not legal counsel, of course, would like to speak. If you would, please raise your right hand.
Yes.
Keep your right hand up. Do you and each of you solemnly swear that in the matter now in hearing, you will tell that your testimony will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. That being said, if we could be briefed by the clerk's office.
Okay. This matter was most recently heard here on April the 17th. At the hearing, it was determined that Mr. Wood would prepare an order that would refer the matter to circuit court. However, in order for that to happen, we would need, or the commission would need to approve final settlement, and then Mr. Wood would be able then to appeal the decision to the circuit court. So that's why we're back here today. I don't have anything specific. I do have the file here.
If I could see that, please.
Yeah, anything you need. There was a petition that was sent in by Mr. Wood, and then a response to this petition by Mr. Shuck.
And you can look at it first.
I have more copies of my response
You have
brief.
more?
Yeah,
Okay,
yeah.
if
If
you
they,
wanna-
I have
he has
more copies.
If you
of my
would
response-
not
yeah, of
provide
course,
that,
of
then
course.
we can begin discussion for
I
sure.
have 4 copies, Mr. Tucker, if you want one, too, I don't know.
Please,
Yeah. There you go, sir.
I'll get you.
Look for it when the final quick enough.
Thank you.
Actually keep stuff.
And if you could please, let's see here.
Who goes first?
The objector is represented by Mr. Wood.
Yes.
Yes.
So Mr. Wood, if you could briefly just bring the commission back up to speed of what the objection is here, and we can go from there.
Yeah, absolutely, Judge. The first notice of objection, and let me say this, it appears that there was some issue involving whether or not a pleading had been filed with the commission identifying the specific objection to the final settlement. As a result, I filed what you have in front of you, called a beneficiary supplemental petition and bench brief, and it has several exhibits to it. That was filed here, I think, on July 1st. Yeah. So what we have here is, Judge, or Commissioners, is Mr. Tharp died on April 23rd, 2016. Ultimately, Connie Sue Tharp was approved as executrix and filed her appraisement of the estate. The appraisement, which I've attached to our bench brief for you, indicated a sparse $500 in the estate of Mr. Tharp, and that was it. Upon further review of the assets of Mr. Tharp, on February 17, 2017, Mr. Milam, as counsel for the beneficiaries, sent a letter objecting to the final settlement filed by Ms. Tharp, indicating that the beneficiaries believe that some assets of the estate of Oscar Tharp Sr. were omitted from the final settlement. Those assets being over 20 different bank accounts and amounting to approximately $250,000. Beginning in February of 2017, February 17, 2017, the fiduciary commissioner, at that time, a fellow named Bischoff, filed a report of findings with the commission. Again, this is in what I have kind of sent to you guys. Indicating that the objection that the beneficiaries had filed should be denied. That recommendation was not accepted by the county commission, was denied, and rather the county commission referred this to another fiduciary commissioner named Harley Stallings. Harley Stallings then began investigation into these various bank accounts that I mentioned and obtained copies of the signature cards and the bank accounts information. That information was provided, various bank accounts, to the county commission, and the bank accounts were filed under seal. And you have those bank accounts in your file, but they are under seal. Okay. You'll notice that all these bank accounts, well, before I get to the merits here, so after Harley Stallings found these existed and the timing of these transfers when they had occurred, he recommended, he held a status conference and recommended that a hearing be conducted into whether or not the transfer of these 20-some bank accounts made on December 28th through December 30th of 2015 were actually bona fide gifts from Mr. Tharp to his wife, or not. Of importance at this point is the commission should note that Mr. Tharp Sr. Was admitted to the hospital, Summersville Regional, on December 15th, 2015, was discharged, a very sick man, we testified to that, on the 23rd of December. On the 28th of December is when Connie Tharp started this process of wheeling him down in his wheelchair to these banks to sign new cards titling these various $250,000 worth of accounts in a joint name with right of survivorship. So the question becomes, was there constructive fraud involved in the retitling of these accounts days after Mr. Tharp has been discharged from the hospital? I haven't read, the law for you guys on that issue, but it's pretty clear. So what we're here today on, now getting back to the alternate fiduciary, can't remember his name now. It's not Bischoff, but
Stallings.
Harley Stallings?
Stallings, yeah. So Stallings, in his November 6, 2017, excuse me, the January 9, 2018 status conference order, the court entered, your commission ordered a status conference in order that this matter be referred to the commission for hearing to take evidence regarding this issue of whether or not this was a bona fide gift days after being discharged with life-threatening problems, or was this constructive fraud? Eventually, in May of 2021, these beneficiaries hired me to represent them. We immediately started seeking to have a hearing with the fiduciary commissioner. At that time, Cindy Whitlock was appointed. What Ms. Whitlock did, with all due respect, is all she did is refer it to the sheriff's department to see if there was any criminal fraud involved here. We know that the sheriff did not believe that there was sufficient evidence to prosecute for criminal fraud. However, Ms. Whitlock then resigned, and the county commission, we again requested the fiduciary commission to be appointed. The county commission appointed Michael Anderson out of Raynell to be your fiduciary commissioner to take evidence concerning this issue. My office contacted Mr. Anderson several times, got no response. Finally, I found out that in November, I think 2023, he passed away. And since then, we have been stuck in this limbo. We don't have a fiduciary commissioner to take evidence to make recommendations to the county commission concerning whether or not this transfer of title to these many, many accounts was actually a bona fide gift versus something else. There are several cases in West Virginia dealing with this issue. I can get into the law on that on another day, or once we submit specific proposed findings of fact and conclusions of law. But quite frankly, Mr. Commissioners, we're still kind of waiting on to have a hearing on to take the evidence and make a record, because the circuit court then, depending upon what the recommendations are, what the commissioner decides, if indeed these assets should be included in the estate or excluded, either party may want to take an appeal to the circuit court, acting as an intermediary appellate court under the case of Kasdorf versus Kasdorf. So we're here wanting to present evidence in an appropriate forum involving the facts surrounding the transfer of title of these assets days after Mr. Thorpe was discharged. Many accounts. And again, you have and that's why Harvey Stallings, quite frankly, recommended that hearing be held. And frankly, that's also why this commission denied Bischoff's recommendation to close the account. So that's where we're at.
Mr. Shuck, if you have a response to that, please.
Yes, I do have a few things to say. So, first of all, I'll begin. His main objection is he has sent Mr. Wood essentially. I'm getting some playback on this. Can you, Mr. Wood, could you mute your mic?
I think this would be, to come out Wolf.
Oops. Oh, that's great. If you would hold on one second.
Yep.
Let's regroup on.
Recording in progress.
I'm not real sure.
Okay,
Mr. Wood, are we
I
back?
guess I'm back. Something stopped, and now I guess I'm back.
Yes, sir.
Yeah, you froze up for a second. But, okay.
Okay, so what we're going to do now
So
is
that's
ask.
correct, you know.
Okay, we're going to ask Mr. Shuck for a response now.
Sure. Mr. Wood, you may want to mute your mic because we were getting some playback. Okay, I'm not hearing it now. So, I think maybe he froze again. Can you still hear us, Mr. Wood?
Sure.
Yeah, okay. So what Mr. Wood is, I'll just begin with this. So what Mr.
I can now, better than a minute ago.
Okay. So I'll begin with this. So what Mr. Wood is actually wanting the county commission to do is adjudicate a claim of constructive fraud as it relates to the titling of these 20 bank accounts. But West Virginia, now Mr. Wood hasn't briefed the law, but I have. So West Virginia law is clear that the county commission cannot adjudicate claims of a judicial nature, which constructive fraud is. Its jurisdiction is limited to matters of probate, appointment of guardians, conservators, committees, matters relating to apprentices, but it doesn't have equitable jurisdiction, which it would need to adjudicate a judicial claim like constructive fraud. So what would have to happen, the end goal for him in this is to retitle the bank accounts and compel a distribution of that money, or if it was gone, award a judgment. And the county commission, I wish the county commission did have the jurisdiction to resolve this dispute, because we could have already gotten a lot of it out of the way, but it simply doesn't. And litigating it before a fiduciary commissioner wouldn't make that okay, or give the county commission the authority to hear that kind of a claim. So all of that is explained in a lot greater detail in my brief. I cite syllabus points from the West Virginia court, most notably syllabus point 3 from Travis versus Travis, which says, and this is a direct quote, "County courts are vested with primary jurisdiction to settle accounts of personal representatives, but such jurisdiction may be interrupted by equity where there is involved some question of equitable cognizance, as, for example, the construction of a will, fraud, waste, and the like." So what Mr. Wood is trying to get the county commission to do is actually improper for it to do. So, and Mr. Wood also wants to kind of downplay the report from Deputy Evans that is already in the record. Mr. Evans examined medical records, he talked to family members, he went and interviewed employees of the bank, and all of those showed that though Oscar T. Tharp was a sick man, he had capacity, and he had the capacity to undertake his own financial transactions. So that report there is the best evidence that we have. It was done closer to the time. We're 10 years past that now. I don't know what evidence Mr. Wood wants to put on in a hearing 10 years after the fact, but the record is already strong, pointing the opposite direction. So I think the proper way to resolve this, if Mr. Wood does want to go to circuit court, is take the suggestion of Ms. Brown, enter an order approving the final settlement of the estate, and then he can appeal that to circuit court as an intermediate court. So that's my response.
My concern is this. Before the fiduciary committee, once it goes to circuit court, there's no new evidence taken. It's based upon the record that was created before the county commission. Now, I agree with counsel that a fraud case, you can't adjudicate a fraud case. The problem is that we have no record. Randy and I looked today, there's no recordings or no transcript of anything that was done before Clint Bischoff or anything that was done before Harley Stallings. I don't think Ms. Whitlock had any hearings, so there is no record. That being said, and frankly, I don't know why in the order from the county commission rejecting the final settlement, it doesn't give a reason why it was rejected. It just says it was rejected. I think if he wants to adjudicate a constructive fraud case, that's a separate action, has to be filed in circuit court. And if he does that, he could, the proceedings here can be stayed until that gets resolved there. I don't know how, frankly, I don't know how to proceed on a constructive fraud case because you do not have that jurisdiction. You're a probate court. You hear matters of probate.
If I might respond,
yes,
just very briefly, since it's our objection. I'm going to cite a couple of cases here that first of all, counsel for the executrix does not cite, just so that you have them. That is the case of Kasdorf versus Kasdorf. This is a 2019 case. You'll find that at 2019 Westlaw 4257186. Of importance in this case is a Supreme Court case where a county commission in Kanawha County took evidence through a fiduciary commissioner, made findings of fact and conclusions of law involving constructive fraud in the retitling of assets, the failure to include assets in an estate. Again, the other case is Barnard versus Reed. This is 196 West Virginia 142. And of course, Versalati versus Lowen, 179 West Virginia 650. With all due respect, the county commission, through its fiduciary commissioners, in matters of probate, when the question is, should assets be included in a probate estate versus not, that's exactly what fiduciary supervisors do. They hear objections, this should be included, that should be included, this should be excluded, that should be excluded, and then they make findings of fact, conclusions of law for the commissioners. You either accept it or reject it, and then there's a record made. And then however you decide, the other party can appeal that to the circuit court. That's what happened in Kasdorf. Now, I came on board in May of 21, and that's continued to follow up with trying to get a hearing with a fiduciary commissioner, which this court has referred the matter to. And of course, we've had problems in Nicholas County with fiduciary commissioners being able to hear this. Specifically, just Harley Stallings, he did a fine job, but then he went on to become a judge. Then Ms. Whitlock, she did what she did, just referring it for criminal investigations, then resigned. Then Anderson dies. So, we're still stuck with an objection to the final settlement being made by these beneficiaries, but no evidence has been taken by a fiduciary supervisor to allow you commissioners to make a decision whether or not these assets should be included as a part of the probate estate or excluded. So that's why I'm still here talking to you. quite frankly.
I say you have two options.
So, I mean,
You
Would
can
you mind
refer.
to step up? So-
No, not at all. I see two options for you. You can refer it to a fiduciary commission if you accept Mr. Wood's argument. You have the right, frankly, to reconsider the action of the previous commission and accept the final settlement, and then that can be appealed to circuit court.
So it looks like we just crossed the eight-year time frame for this. And my goal would be to get it closed out. I mean, honestly. And I don't feel that we're properly suited to determine criminal type of activity or anything like that. So my recommendation would be to accept the final settlement and let them move on with that.
What is our status of fiduciary commissioners at this time?
We have none.
Right.
I
I would
mean,
have to search.
when I say refer it, I mean refer to yourselves to have a hearing because we don't have fiduciary commissioner. So you have those two options available to you. And as far as criminal referral, that should never have been done. I mean, this isn't a criminal matter. It could have turned into a criminal matter maybe, but I don't think she had the right to make that referral. So,
The previous
yeah,
fiduciary.
which is neither here nor there, but the investigation was done and Mr. Evans, Deputy Evans made his findings. But those are the two options I see here.
Can I respond just briefly?
Yes, sir.
Yeah, oh, so I'll be really quick. I just want to respond briefly to what Mr. Wood said. So it's a little bit, this case here, Kasdorf McNeil versus Kasdorf, is what he's really hanging his hat on. It's disingenuous for him to say that it's an opinion from the Supreme Court. Yeah, technically it is, but it's a memorandum decision. It has no binding precedential authority. And the issue, so it's true that the county commission took evidence of a constructive fraud claim, but their jurisdiction to entertain that was never raised on appeal. It just happened. It happens sometimes, but it doesn't make it proper. And there are several Supreme Court cases that are binding and have precedential authority that went the other way. So, also, I don't see the utility in having a hearing before the commissioners or a fiduciary commissioner, because what relief are you looking to get? He's looking to retitle the accounts of the estate and compel their money to be distributed. It just can't be in the county commission. So that was my brief response.
A question I have is, I see here where it talks about the bank accounts being sealed. Is the money still there?
So I will have to look into that and get back with you.
I think I asked you that last time you told me that, so I'd like an answer.
Okay.
Number two, explain to me, and Greg, you can probably explain it better. In the will, the bank accounts become joint property, right? When they open the accounts and put Connie and Oscar's name on them, they at that point become joint property.
Once they went to the bank and did that, yes.
Okay,
With survivorship.
so half was his and half was hers.
Technically, yeah.
So with the kids getting their 50,000 and 5,000, things like that, should that not have came out of his half anyway? Because he owned half.
It was survivorship account, so when he passed, that money would transfer to her.
All 100%.
Yes. It would have been non-probate.
it all went to Connie.
Which is quite common, frankly.
Right or wrong, but it's.
Is Connie Tharp still alive?
Yes.
Okay.
When did he died in April?
Yes, 2016, I believe, wasn't it?
23rd. We're going to take a quick recess. We are back from our recess. Again, we are still here on the estate of Oscar Tharp, file number 9170 after a requested recess. No decisions or conversations concerning this estate has been made by the commission outside of the recorded meeting. That being said, is there anything you would like to say or would like to ask more questions of either legal counsel?
Would you like to make a recommendation on what we should do?
Well, I think if you want to hear from either counsel before I do that, might be appropriate.
Okay, let's begin, actually, yeah, let's begin with, basically, of course, we're not judges, so I don't know what to call it, but I'm gonna call it closing arguments here before we discuss this with the legal counsel here in the meeting. We will begin with Mr. Henry Wood, the challenger of the estate, representing the challengers of the estate.
Yes, sir. Okay, Commissioners, Mr. Tharp married Connie Tharp on February 20th of 2013. On June 6th of that year, he prepared his last will testament. And as you can see, attached to my submission to you all, and in your record, already been filed, is his last will. In that last will, he details, in great detail, he gives money to his children, his grandchildren, and great-grandchildren. Both Natural and Connie's son, his grandchildren, her and great-grandchildren. Mr. Tharp was not well at that time, suffering from COPD when he married. On December 15th of 2016, Mr. Tharp was admitted to the Summersville Regional Medical Facility. On December 23rd, 2015, Mr. Tharp was discharged, having survived some critical COPD medical issues. In fact, so critical that hospice was called in, and the testimony would be that Connie Tharp did not want to speak to hospice at all.
I object on the record to that.
Okay.
That's fine. You can object all you want. I've got 3 witnesses here to that. December 23rd, he's discharged in an ambulance home. 5 days later, Connie Tharp, his wife, who had been named executive in his will, in a wheelchair, takes him over to the banks and has him sign new titling documents, titling numerous bank accounts, totaling approximately $250,000 from his name into their joint names with right of survivorship. Remember, this is 5 days later, sick man. Approximately in April of 2016, April 23rd, 2016, Mr. Tharp dies. Connie Tharp is ultimately appointed executor. She files an appraisement as required, showing a scant $500 in the estate. This man owned a home, he owned property, he owned cars, he owned at least $250,000 in bank accounts. But of course that's absent from the appraisement because the titling of those monies had been changed into a joint tenancy right of survivorship titling. So when he died, all that money went to Connie, thwarting the intent of course, Mr. Tharp to give $50,000 to this person, 50 to this, 5 to this, 1 to this. Great detailed will that had just been prepared 3 years earlier, just less than 3 years earlier. So the question arises, under the case law in West Virginia, was that a bona fide gift from Mr. Tharp to his wife by retitling those assets as joint assets with right of survivorship? So when he died, she received it all. Or was Mrs. Tharp taking advantage of her relationship, confidential, fiduciary-ish relationship with her husband, being very sick, days after he's in a hospital, almost dying, having him re-sign all these documents so that when he does die, about 4 months later, she receives everything. Commissioners, when you try to determine if a relationship exists, a fiduciary or confidential relationship exists, number one, you have to take all of the circumstances under consideration. Of course, she was his wife. She very quickly after he got out of the hospital starts running her through these banks to sign these documents. She knew what the will said because she was his husband at the time he made it, or his wife at the time he made it. There's several other little pieces of evidence that I won't go through, but that's why we would have a hearing to submit it to you. But just the fact that it's his wife of a very short time, the circumstantial evidence of changing the title to all this property that would have funded all of those gifts to all those children, grandchildren, and great-grandchildren, to retitle that so that she would obtain all that money, really doesn't pass the stink test from our point of view. And we think a jury would very likely, just from that circumstantial evidence, find in our favor. But again, the case law is pretty specific on what you look at. And that case law is certainly the case of Kasdorf versus Kasdorf, Barnhart, Versalati. There are a few cases where the Supreme Court has found, yes, that's constructive fraud. They're occupying a special relationship to the deceased, wife, brother, caregiver, took care of bank accounts, took care of food. We're talking about a relationship here that the executrix utilized to her specific benefit, obviously cutting out all of the children of Mr. Thorpe. Once that evidence is presented to you, or a jury, if it has to be, if it ever could get to the jury, we're confident that these assets would be placed back, would be ordered to be included in the estate of Mr. Thorpe, and then that money would be distributed according to his desires and his will, and not left and not considered a gift to his wife 5 days after he's out of the hospital. So we believe that a fiduciary commissioner could conduct a hearing, get the evidence, make recommendations to you folks, and you decide whether or not that asset should be included in as assets of the estate, probate estate, or not. Or was it a bona fide gift? Did he just decide one day, well, screw all my children, grandchildren, great-grandchildren, I'm going to give everything to Connie. And they get nothing, ever, out of my estate. $500 was the only thing that she had listed in that estate. But that's where we're at. And respectfully, I'd ask that a fiduciary commissioner somebody be determined to take evidence. I think that's probably most appropriate at this stage, make findings of fact and conclusions of law. And then, of course, that evidence is present, and then that, depending on who loses, they can appeal to the circuit court. We don't think we will lose, but of course, I'm a lawyer for the beneficiaries, but the facts are very clear. The dates are very clear. The illnesses, the intent of the testator is very clear. Thank you very much, Judge.
Thank you. Mr. Chuck.
Yeah, sure. So you guys heard it there. He's wanting to turn this into a circuit court hearing. And that's what he's wanting, is for you guys to adjudicate a circuit court issue, and it just can't happen. And I objected on the record to him talking about all the evidence of the transfers that happened prior to Oscar Tharp's death. And I'm not going to go into it now because I think it was improper, but I will just say for the record that he grossly misrepresented those facts. So you heard him say that he believes a jury would find in his favor. Well, there's no jury in the county commission. If he wants to have a hearing on this, it has to be in circuit court. The relief that he's requesting the county commission grant him, it doesn't have the authority to grant it. I wish it did, because we could resolve it here, but it just doesn't. And that's all I'm going to say in my closing remarks.
Thank you. Legal counsel.
Hey,
Can I ask a couple questions? Sure. You're representing Mrs. Thorpe?
Yes.
So in your opinion, maybe you could say you can't. Do you feel like Mr. Thorpe was in sound mind when he went to the bank and done all this stuff? And do you think it was his intention to take his kids out of the thing by doing this?
So I will defer to the Chief Deputy Evans's report, who investigated it far more thoroughly than I did, and around the same time that this happened. And he found his findings based upon a review of medical records, consulting doctors, consulting family members, consulting the employees of the bank, that he did have capacity to undertake his own financial transactions. So based on that report, somebody who was more knowledgeable with more experience in investigating the matter than myself, I would say that yes, he had capacity and wanted himself to change change the title to those accounts to a joint tenancy with Connie Thorpe.
And to add to the record, this letter from Chief Deputy Johnny Evans of the Nicholas County Sheriff's Department: nowhere could I find that Mr. Thorpe was deemed incompetent, although appeared to be very unhealthy. You may continue.
Yeah, so the second part of my question is, do you think he had intent to take his kids out of the will?
Well, so under West Virginia law, whenever someone retitles a bank account, it's presumed that they intended it as what's called a causa mortis, bona fide causa mortis gift. So Connie Thorpe is actually entitled to the benefit of a doubt that he did intend that as a gift.
I didn't ask that question. I asked if you thought his intent was to take his kids out.
I don't think it's appropriate for me to, but yes, I do believe that his intent was
kid,
his
what do you
intent.
think?
Well, no one's asking
Whoa,
me
whoa,
questions, sir. No. So I would say that yes. I mean, based on all the evidence that we actually do have, yeah, that had to have been his intention.
So if he was competent enough to do that, and he wanted them out, why didn't he change the will? He would have had plenty of time if he was competent. Why didn't he change the will at that point? We're making codicil to it to take them out.
Well, he died. Commissioner, he died.
He
before
died
could
4
change the
months
will.
later.
Yeah, but that was when he changed the title to the bank accounts, the specific monetary bequests in his will were deemed. There was no reason to revoke it. I mean, the bequest was already deemed. There was no reason to execute a codicil or a new will.
But as somebody in sound mind, I would have to realize that this is going to be the result if I don't change my will.
Yeah, and he was so detailed in everything in the will, it's kind of hard to believe that he didn't want that to still happen.
Yeah.
I think he was detailed enough of a person that he would have done it that way as well.
Well, how can you say if he was that detailed of a person? How can you say that
I'm
he
looking
didn't
at the
intend? Well, I know, but how can you say that he didn't intend what he was doing?
He went all the way
and
down to
change
the
it?
grandchildren with a specific dollar amount in that. So that's my question to you that you can't seem to answer, and I understand that some things you can't seem to answer, but it does seem to be you make it sound like there was a process, but it was only halfway done. And I don't feel from what I've seen Mr. Thorpe being halfway done. He would have completed it to the end if that was his intent. That's what I see. And listening to both sides of the argument.
You raised your hand.
Yes. 2 weeks before Oscar Thorpe Sr. died, he had all of his children and grandkids come to his house. Connie presented them a copy of the will, and he had them to read the will and says, "Are you satisfied with what I'm leaving you?" And when I know, so with that part there, if he had intentions of changing his will, why would he have his kids come in and ask them if we're satisfied with the gift he's leaving?
Were you ever briefed by Ms. Tharp of that meeting?
So I've talked to her. I didn't come prepared to argue that today. So I have talked with Connie Tharp multiple times over the phone, but it was a long time ago, and I didn't come prepared to argue at a circuit court hearing today the facts of the matter because I think it's improper. I think we're getting into the weeds with those facts here because it's a judicial claim. Constructive fraud is a judicial claim. It shouldn't be litigated in the county commission.
I don't think we're litigating, we're just trying to use maybe intent as a factor of which direction we're gonna go.
Yeah, but so what would be the relief that you would grant? I mean, are you going to retitle?
That's what we're trying to decide with the information.
Yeah.
Do we
So
want to accept a final settlement or do we don't? I think that's what we're trying to do.
Because with due respect, you know, if you find that there was a special relationship, and if you find that there was this overreach, these assets are then included in the estate. They have to be placed back in the probate estate. That's why it's in front of you guys, and that's why there was an initial a referral. You have all the bank accounts, and the fact that I know there's an issue of competency here, and truly there is an issue of competency. But even beyond that, commissioners, you know, if I'm an old fella and my wife says, I'll take care of this, you know, retitle all this, it'll be easier. I don't know what she said to me to do this. Be easier this way, you won't have to go through probate, I'll take care of everything, I'll make sure the kids get what you want them to get, etc. Whatever. You know, a person in the position that she's in should never have done this, number one. But Mr. Tharp may have believed his wife had his best interest at heart and was going to follow through with exactly what he wanted in that will, which she knew of. He's not a lawyer. And, you know, he's not, even though he's a smart fella. You can envision a conversation a wife might have with her husband who's very sick to make things easier along the way when he passes. To just title everything in my name, I'll take care of things. I'll make sure the kids get what they want, won't have to go through probate. I'm speculating. But beyond simple competency, a person in the position that Connie Tharp was in has the ability to persuade her husband, just like any confidential or these type of relationships, to take action that may not be consistent with their intention, although the person somehow getting them to believe I will take care of it. So it's even beyond a competency issue. It's this special relationship that exists that the case law talks about. So.
And if you don't mind, just for the record, real quick, I'd like to ask, is there a reason why Connie Tharp did not appear?
Oh, she lives all the way in Texas outside San Antonio, so she wasn't going to be here in person.
Well, as I mentioned, I think you have two choices. Apparently there was a hearing, and there was a recommendation by the fiduciary commissioner, Mr. Bischoff, and I don't know what happened. It's not disclosed in the record why that commission at that time rejected that recommendation. But you have two choices. You can refer it back to a fiduciary commissioner to take this evidence again, or you can reconsider what the former commission did, and then vote to either accept or reject that final settlement. Either way, it's going to circuit court. I mean, either way, it's going to go. So that just gets it to circuit court quicker.
So if we accept the final settlement here, then they have the right to go to circuit court with it, and that's the Courtney's path. All right, does that, like, I can't get an answer on the bank accounts properly that I want. That doesn't release the bank accounts at that point that they can spend the money with.
Well, I don't think that, I mean, right now the records are all that's under seal. There's no control over the bank accounts at this point. You have no control over them.
I thought it said that in one of these.
I think they're just, I think the record, I may be wrong. I haven't read Mr. Salving's order completely, but I think all that happened was that the
Could you give?
records were submitted to the judiciary commissioner, and access to those was placed under seal.
I believe that's correct. I'll find it.
So at this point, there's no order that addresses those bank
Mr. Counsel, how do we deal with the issue of findings of fact and conclusions of law when, you know, you need that to take it up to the circuit court?
Mr. Bischoff made those.
Well, but that was denied, and then separate subsequent alternate commissioners, you know, were trying to schedule hearings. I mean, but where do we get our findings of fact and conclusions of law with respect to this issue?
Well, I mean, the commission has the right to reconsider the action of the former commission and accept those findings of fact and conclusions of law. Either way, I mean, frankly, either way, if they accept it or reject it, it's going to go to the court.
Of Mr. Stallings in that file.
Well, I would ask counsel for the executive if they agree legally with that proposition. Do they agree that no matter what the commission does here, that the beneficiaries or that have the right to appeal and panel a jury since no evidence has been taken on this issue?
Well, so, no, well, yeah, what Mr. Tucker said is right, of course. I mean, any order that comes from the county commission can be appealed to circuit court. I feel that would be fairly non-controversial.
Well, it's controversial when you go to the circuit court and say you can't take evidence. It's too late.
Well, I don't think you're going to get a jury trial either way.
Yeah.
Well, if you take no evidence at this level and you go to circuit court and they take no evidence, that's a problem. That's not a remedy. That's not a remedy.
Well, that's probably why there should have been a separate civil action filed for constructive fraud.
Well, but again, the Castor case clearly shows us a way, a path through the county commission, making findings of fact, and then you appeal that to the intermediate, as an intermediate or appellate court to the circuit court. You know, if indeed the discussion here suggests that no matter what the commission does here, you can go to the circuit court and have an evidentiary hearing with respect to constructive fraud. Of course, that's okay. But if indeed that cannot be done, then again, that's a problem. This is a you know, we don't have a remedy here. And this objection was filed in November of 2017. I don't think that anyone can point to any person being dilatory in trying to have a hearing. We've been through I've been through 3 commissioners trying to get this to a hearing. Special commissioners, fiduciary commissioners. You know, and what Mr. Whitlock refers it to a sheriff for criminal investigation. Nobody understands that. Nobody understands why that even occurred.
I agree with that.
That's a completely separate standard of, proof. That's a completely separate matter. That has nothing to do with constructive fraud. It has the word fraud in it. That's all it is.
Records under seal. Is that what
Yes, please.
you're looking for?
Thank you very much.
Fiduciary Commissioner Bischoff placed the records under seal. Which are still under seal.
Legal counsel, would you review this, please? Sure. Make sure I understand this properly.
All it does is place the records under seal, and no one should have access to them. It does not
Access to the
records.
records, not tying down the funds
No,
or
it
anything
doesn't.
of that sort.
No.
That's what I thought. Okay, thank you.
There's no order to preserve those funds.
Is it, if we send this back to another fiduciary, it's just gonna go around those circles, just like it is now?
Yeah.
We don't have a fiduciary.
That's what
I mean, it's you all.
We'd have to have our own hearing.
Do you lean strongly either way?
No.
Any further discussion or motions?
Can we be like the Supreme Court, take a few days and get an answer on the next meeting?
You cannot, outside of this meeting, discuss the case.
Right.
You can consider it in your own minds, but you can't have discussion. I mean, and you can individually discuss it with me, but you can't, the three of you or two of you get together and discuss the case.
I just want to get it moving forward. I mean, not in the essence of our time, but in essence, the fact it's been 8 years. Whatever the path, the progression of that is to a final determination is my ultimate goal.
Can we review all this stuff and get a decision at the meeting?
Oh, you can table it, yeah, you could.
I mean, I have no objection to that. Yeah, I have.
I would like to make a motion that we discuss or go through all the evidence, because this is a lot, with amongst ourselves.
This is
individually. And at the next meeting, which is the 24th,
yes, sir.
will be put on our agenda for our decision.
Okay, that motion's on the floor. Is there any other motions or comments or questions?
We'll have a motion that day, though, right? Yes.
Hey, Commissioners, do you need council present at that hearing? If you do, I'd like to request a Zoom presence, or if you don't need council present, that's fine.
Actually, why don't they both just do Zoom?
Peter's going to announce.
I have no
Both
issue with
council
legal
present,
counsel
okay.
being.
May I appear by
counsel being
Mm-hmm.
Zoom?
present. Yes, sir. Yes, sir. Is that there's any objection? I have no.
Okay.
Yeah, I have no problem with that.
Okay.
I mean, at that point, I would assume that you're not going to accept any further argument. You may discuss it among yourselves, because that'll be your next opportunity to do that. But you'll just do that discussion, and then somebody will make a motion one way or another to conclude it. But I don't think at that point you should take any further argument from council.
Unless there's some kind of new evidence, and they
Correct.
think they should bring it to you, and then you bring it to us.
Right.
And then we'll go from there.
Did you hear that, Mr. Wood?
Yes, sir.
Okay.
Yeah,
Any further
If you don't
evidence
feel
will go
it-
through
If you don't feel
legal
it
counsel.
should come to us, then
Tucker.
it dies right there.
Okay.
Well, after 10 years.
Okay. That motion's on the floor. Any further discussion? Anything else from legal counsel?
That's it.
Hearing none, all those in favor signify by saying aye.
Aye.
Aye. All those against, the motion does carry. So, need a little time to think it over, but we'll individually get with Ms. Brown and review the file once more and get back on the next meeting.
You all
Thank
get
you.
out. You need a copy
Thank you,
of this?
Commissioner.
Where,
What is it?
where hospital, when the hospital asks for Connie by half the hospitals come in.
Recording stopped.
Say-
We can't have the evidence, we
Have the
can't take
evidence.
that.
Why don't you give that to him?
Recording in
Review it,
progress.
And then
Well-
decide.
Henry probably has that. Why don't you have Henry submit it today?
I don't know if he has not, because he's the one told me to bring it today.
Well, it doesn't just need to come to me, it needs to come to him as well. So Henry will know how to do
Yeah,
that.
get with Henry and he can distribute. Okay. Thank you all.
2 weeks, we'll have.
Each of us schedule with you to come in and review.
Okay, okay.
Yeah.
So that you don't have to like wade through, because you know, there's just like correspondence that's not
Right.
necessarily something you're gonna have to look at, we just keep.
Right, yeah,
Okay.
if you could prepare it in that manner, and each of us will get with you too.
That's probably better, especially for the bank records, so they don't get out.
Are they allowed to unseal the bank records?
They can do what they want.
They can do what they,
I
oh,
like that. Thank you.
Don't say that. Okay, thank
all
you.
right, thank you.
When you say we,
All four of it.
you're talking we can unseal.
Sorry.
You all can look at it, yeah.
But not
Carry that
reproduce.
for you,
But can we
Brandy.
look at
Like
them
that.
to where they are
Okay.
present day, or just where they
We'll
were?
get with Mary for a time.
Times.
I would say we only have right to the file.
My guess is those bank records are in Texas for the current day, if they exist at all.
I would just have whatever they sealed at the time of the order.
Right, that's all you have.
Yeah, that's all
Well,
I
actually,
would
all you're
have.
entitled to is what at the time of death.
Then,
I tell you
Can
what,
they,
what that kid said right there carried a long way.
Oh, I can see you struggling with it, absolutely.
Absolutely.
Can, through code, can they view the 6.02?
Yes.
Okay. All right,
Were those included on that?
I believe so.
That's the non-probated.
Yeah, I couldn't find it in the file, so yeah, I definitely see
No,
that.
it's not in the file. It can only be released to certain people.
Okay.
So the question I have, I kind of asked it the last time, I don't know if I could ask it any clearer, but it's probably not clear, is does the will take precedence over, in other words, is the will still all saying, even though they were married and those accounts were joint?
Afterwards.
The law would be just, I'll give you an example. My wife and I have joint accounts, survivorship. I also have a will. But the survivorship joint accounts, that contract takes precedence over my will.
Okay. Whether performed before, during, or after the will preparation. Okay.
Just know
That's
that you're
contractual.
not, if it eases your mind, David, just know you're not saying what she did was right or wrong.
Correct.
Sure.
You're just making a decision.
Sure.
I understand that's tough. Like, I can see, you know, this woman has the soul vein to be sick. But if that helps you, just know you're just making a overall decision. You're not admitting her innocence or guilt.
Very good.
All right.
That being
Unless
said,
you have a hearing. And then you have to figure it out.
sure. Okay, that being said, we will take a quick recess. In the meantime, what I would like to do is request a agenda amendment. We did skip over the 9:50 appointment. If we could come back and address it, please. Is there any objection to that? We get Gary back in here. Is there any objection to amend the agenda to revisit the 9:50 appointment that we did skip over to get to the estate? Okay, so that being said, we'll take a quick recess. Okay. Back to the agenda item at 9:50, I had a few requested items. We'll go through backwards here. The one room schoolhouse, we did have a insurance adjuster on site reasonably quick. However, our insurance company, and Patty, correct me if I'm wrong, has not received the report back to proceed with any kind of repairs or anything of that matter. Is that
My
correct?
knowledge, that is correct.
Okay, is there any way, and actually I hate that legal counsel just left the room, is there any way that we can try and push that along or anything? I mean, the
I
building's
can
just
call
sitting
them
there.
again. I mean,
Who's not got the contract?
The, the adjuster.
Hasn't submitted the report to the insurance.
Yes, but he has been on site and take photographs.
they do have the airports.
How long ago
Yes,
was
the
that?
airport,
Do you know?
April 4th was a storm, but,
Yeah, and he was there, what, 2-3 weeks after the storm?
so probably in April.
Probably.
Just safe guess, so yeah.
But they okayed the airport, is that correct?
Yes.
That one's okay.
It's already in progress.
It's already in progress. They haven't received their check yet, but she's working on it. He did get the airports to her.
It was April 4th?
Was the storm.
So we've already hit 3 months.
Yes, sir.
I think it was later than that.
I think it was later than that.
It was later. I think because it took
Okay,
us
May.
3 weeks, I think, to get it in.
Yeah.
So like I said, we're incurring additional damages that.
Yes, we are.
Yes. And if that falls back on them, I feel they should pay for it at no expense to us.
Just like them.
I mean, it's an insurance company, that's what
We
we pay for.
reported it all
Correct.
right when it happened, right?
Photography and all. I went around and got pictures and, Ms. Neff sent it in.
What's going to be the final course on that? The recommendation, one site, his recommendation was that it would cost too much to rebuild, something along those lines.
So it's that, it
Which I'm
costs
s-
more to rebuild than to tear it down and build again.
Right. which I'm assuming excludes the historical value. I mean, we're not gonna build something, say this is what the school used to look like, right?
Yeah, I have an objection to that theory.
I have a contractor that says he can.
But on the other hand, at that same, probably the same day he talked with Sally, he talked to me on the phone. I didn't meet him in person, but he did say he did not know how much coverage we need to have in the building.
Gotcha.
So,
Rodney
in all
McClung.
fairness,
Thank you.
There he is.
Rodney,
he told me that.
if you don't mind to sit in here, we're gonna talk here in just 1 minute about something.
Okay. What was the estimate, Sally, on the 34?
Thank you.
31, 34?
Somewhere in
So,
The one bid we received.
yeah.
Now, when that was brought there, was it taken apart or was it just trucked?
I heard from a lady the other day that they brought it there and put a new roof on
So they trucked it there
it.
and
So
roofed it.
that's
all
why
over the
the
roof.
rafters and stuff are new material.
Gotcha.
She's supposed to be bringing me pictures.
So
of
who
that.
actually owns
Is that
it?
the one in school?
I
The,
guess we
so the theory is, and there's always been a disagreement, but everything that I could find in any kind of records that I've reviewed and actually spoke with legal counsel about, anything that is constructed on park property that is not movable, which would be an example of like bleachers, everything else the county does assume ownership of. Regardless of who donated it, how it got there, who paid for the construction.
Because it was moved there. There's
It
an
is.
argument itself.
Well, and I guess it would be kind of like in a housing situation, like it's been placed on a permanent foundation versus like the axles are still under a mobile home. Yeah.
Well, if it can't be, I mean, maybe the best thing to do is, if it can't be rebuilt, maybe you could build something with that money there to represent it.
Perhaps. I'd like at all costs to salvage it at all costs, but I mean,
Well, if they've already put a new roof on it, you probably could change the rafters.
Yeah.
and
right.
put a new roof.
I think, I mean, absolutely, there's at least probably, I'm gonna say at least 50% of the rafters would have to be replaced.
Yes, and you could either get somebody skilled to go and do it, but I don't think that dollar figure is probably high enough for that, so you just have to keep that one as an open claim until it's completed.
Yeah.
Because you need a specialty contractor right there. really.
Yeah, you're right. And I have reached out to Randall Reed Smith, who's the curator, when he's the Secretary of Historical, I can't remember his true title, it is the Secretary of History for the state of West Virginia, and he put me in contact with one of his representatives, but she's honestly kind of waiting to hear back, like we are.
Probably Mike Childs too, you should probably call him, because he works with that. Remember, he did the architect work with Dan down at the 911?
Yeah, we might even see if we could, what he would charge or whatever, and come back and see if it might be worth even just hiring him as a contractor to do his own independent review.
I think the biggest thing is gonna be determining how much money we're gonna get out of that, right? I mean, what the insurance is
We
gonna
only
pay.
have it insured for like 25.
So if we got the 25 Mac, that's not enough to fix, based on the estimate. They said new roof and squaring everything back up again.
And windows.
And windows.
Windows, first, probably honestly take those out and reglazed at a glass shop. Since they're the original
Yeah,
frames.
they could take the frames and,
Replace them.
if anything, they could reconstruct them to the same standard. You know, if you replace something historical, you're supposed to put it back to the same standard and everything, which surely could be done. And then a note on the Red Barn. I went out and looked at the roof repairs that were done. I do believe they're satisfactory. I wanted Commissioner Roberts, President of the board, to also find them satisfactory first too, but otherwise I'm satisfied with that work. The damages during the storm too that we do need to add to that claim.
Right.
And I do have photographs of the
You will send me the
drop ceiling
photos.
of the first floor of the barn.
And Sally's going to send me copies of the receipts.
Yes.
Then I'm going to send them off to the insurance.
Okay, a drop ceiling tiles as well as light fixtures that were water damaged, and I do have a concern of those being replaced.
The electrical work at the shelter, we captured that as well, right?
That's you.
The original electrical work at the shelter?
Yes.
When the head was messed up, and then when we went back, we had some pictures where the box, the actual circuit breaker box. had
The
all
animal
the
shelter?
working. Yes.
Okay.
Yeah, the animal shelter. Okay. So that's an additional $40-something.
Okay.
So I guess we can see if they give us the full 25, and if they do, maybe we could back up and revisit the contractor, see if if we can get that amount of work done. Maybe they would donate the rest of it, or we could figure out something with that.
Right.
The main thing is gonna be getting the roof back on and getting it squared up. We're just putting the trusses back on, they should be able to pull it in square at that point.
Yes.
You know, if you want to figure in your, I don't know if you could ask for reimbursement for labor for the park employees. You know, why we couldn't.
And for the public record,
Oh,
for the
since we're
public's
doing that.
notice, all contents were taken out and are in dry storage and everything, so it's just the building there. None of the artifacts, historical value, books, desks, everything that was removable is in proper storage during this
My
time.
assumption is that they would reimburse for the amount the building was insured and the tree that had to be removed, the labor part of that.
Oh, we turned that tree in.
Okay.
Yeah,
All right.
it got turned in.
Alrighty.
Anything else about the park while you're here? Okay. Thank you. Also wanted to discuss the courthouse central heat and air, the HVAC. Thankfully, Rodney was walking down the hall, so we grabbed him too. Yesterday, I was out with Mr. McClung, the technician, looking at the unit, and did everything yesterday go well to get?
We just got a Band-Aid on it, it's just running on half of it. So you brought the other side up, they had the leak, and they run 15 minutes and shut itself off.
Okay, so
Not enough
and then was it a compressor yesterday? He might have
fan motor.
a fan motor.
Fan motor, yes.
Did he have it replaced? Did he replace it yesterday?
Luckily, we had one from about 5 years ago, a technician brought up here on the left and didn't install it, so we had it on site.
Okay, but it was installed yesterday?
It was installed.
So there was progress made, that's good. That's good. So then talking to the technician yesterday with Rodney, as well as Tim Mills, who's been to us many times, it does seem like we are a very good candidate for the rebuild proposal versus replacement, which is good. According to a national standard that's name escapes me, that is a 20-year, that is expected to be a 20-year unit, and we are actually only on year 13. It was manufactured in 2011. We did, Rodney and I actually individually, we went and found, with Rodney's help, the data manufacturer was 2011. And this reconstruction proposal that he's been given to us before, and I did ask for an updated proposal, is the reconstruction of both units. It is all the main components, including the compressors, the coils, various electrical switches throughout the unit, sensors, and I believe that's the majority of it, right?
The one that gave us before was for the half unit was a year, and this 5-year warranty.
And there is a 5-year warranty on both sides again for that work and also the entire unit.
Yes.
And for the reconstruction of both units, and I'm sorry I did not get this printed off, but the quote received Monday, July 8th from Trane is $69,652. Now, they did find yesterday that what did we replace yesterday? What was that called?
Fan motor.
And fan motors were not included in that, but the technician did find that really both of them are not in good shape. And so they did say that about a $10,000 variance would include those also, and they would also be part of that 5-year warranty. And so that proposal comes to a total of $79,652. And again, that's all major components replaced, nothing internal, because all the problems are out in the unit itself. And that is what it would take to complete that.
That's not each,
That is combined for both, yes, I'm sorry. That is a combined
Before
price
the
for
rumors
both
fly,
units.
this is a recommendation of Trane to rebuild these.
Yes, sir.
This is not us cutting corners.
The representative-
This is not us patching stuff that's broke. This is a recommendation of the manufacturer itself.
That's honestly what we did yesterday, was the patch to get
I've
us
already
through
received phone
until.
calls and emails on that.
Yes.
That's what, if they feel like it's gonna happen, and no, so it's a recommendation from the manufacturer directly.
Yes, sir. Yesterday was a patch, to be truthful. However,
Right. Yes.
this is a proposal
In the long run.
that a reconstruction of the unit, you're looking at 79,000 versus Tim would not give me a price, and I quizzed him quite heavily, frankly. But Tim would not give me a price on replacement, but he said it would be a very close bet of anywhere between 275 and 325,000. So basically, you're looking at 70 versus 300.
And will this address it shutting off erroneously in off
Well,
hours?
shutting off, the fan motor, it protects itself.
Mhm.
The fan motor was shorting out, and
Right.
it was getting too hot. And
So it
when
shut down
shutting
versus
it
burning
down, we lost our water temperature.
Gotcha.
I stopped in here Sunday and started it, left. 15 minutes later, it shut back off because I wanted to run during the night so we'd catch up Monday.
Yep.
Well, that didn't work.
Okay.
And once we get up, when I come in here Monday morning, 88 degrees. And there's no
Inside
way-
temperature.
Inside temperature courtrooms.
And there's
There's no way to catch that up. No,
There's
not
a
with
metric
half
that
a
you
year.
told me about. You want your water temperature through the
44.
building at 44 degrees,
44, 42.
and we keep reaching
Well,
degrees in
yeah,
the 50s.
Yeah, by this evening, so far it's 44 this morning. By this evening, we'll probably close to 50. Of course, it's not as hot as it will be. Now, next Monday, it's supposed to be 95 again.
So with the $80,000 investment, is there anything that we need to do to upgrade something that makes it work just a little bit better or anything like that? Is there any reason to believe that if we do this
If both sides
remanufacture-
was working, we don't have no issues.
Because when we say both sides, and I'm not just even clarifying for the record, I'm clarifying for myself, one unit will run for a while, has a cooling period while the other one runs, and you're doing this versus one's running all the
If
time
they both
and
need
just
to
kicking
run,
off.
if they both need to run, they will to catch
Or
up.
they both can at the same time simultaneously.
So there's no like small upgrades or anything like that that you feel would be recommended?
No, so until that leak come in now, we've always been able to keep up with it.
Where's the leak? Is
It's
it-
in the top part of the coil.
And the coil.
Okay, $10,000, is there 4 fans?
Yes.
So it's $2,500 each, basically. Now, did you replace a fan motor yesterday? Is that what you did?
Yes, we placed the first fan.
So do we only need 3 now?
You said that was used, that was this.
Oh.
Was it used or new?
Brand new.
Oh.
It was in
Brand
the box,
new, but from
straight
a
out
few
of
years
box.
ago?
Yeah. He
Did the
come up here-
technician mention anything, I'm sorry to interrupt you, did the technician mention anything about that was like an older model of a fan? Or is it the same fan they would be putting in today out of the truck?
It'd be the same fan.
Okay.
What happened was he brought 2 up. The second one was checked out not to be bad. So we'd already paid for it, so
Yeah.
he just left us with us.
Yeah.
How long will it take them to rebuild?
He said it would be a 3-week job. And of course, he would start on the unit that is down.
Right.
And then work on the other, so at least one unit's running all the time. There's never any true shutdown. There might be for a few minutes, but,
Do they pull them out, take them somewhere, rebuild it, put them back in, or do they do it all right there?
I believe it's on site.
On site.
I believe they just bring the tool, the parts, and through the process, just plug and play, is the way I understood it.
Yes.
Okay.
When they drop currently, is there a notification that goes out? Or do you just have to be around here to know? So then we talked about a remote monitoring system at some point that Train has.
Yeah, they have, but it was supposed to be able to, at the beginning, it was supposed to be able to set up to go to my phone, but it.
Yeah, that's definitely what I want as part of this as well.
Yeah, it somehow we got dropped out of that somewhere.
That needs to be resolved as well, because we could capture some of, we could probably got ahead of some of these. I mean, not putting additional work on you, but at least we'd be able to know and prepare for it.
Well, yeah, we have better notification of what's going on,
Yes.
because we're not a 7-day-a-week facility, yeah,
And
absolutely.
it's caught us on both of the holiday weekends.
But
Right.
even if both sides work, it would catch up. Because I come in at 7 in the morning
Right.
and it is up by.
But that's why I said, though, it's both of these 4-day weekends we took, that's when it bids, both of them.
Right.
Thank you, Governor Justice.
And is this Train itself, do we need to look at other companies?
So that was
We're only
actually my
looking at one
request
here.
too. What it is, the way he explained it to me, that this is Train official.
Yeah.
There are only 2 guys in the state, and he's one of them that was certified to do this, and it would not be subbed out. similar to how it was actually put in.
Who's the other?
Two actual individuals that are employees of Train. Yeah.
So for like providing.
And he listed off, like he was at Marshall, he's going to CAMC, he's going to different
Yeah, he's all
state
over the
buildings,
state.
he's all over the state. It would be a 3-week process that he thought he might be able to get to. And he said he should not have a major problem of limping along, frankly, kind of like we are. And probably by sometime maybe the end of next month, he should be able to get that process started. He said there's a little bit of a lead time on the coils.
Yeah.
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 And so that was a little bit of a holdup.
And also the history of this, we had another company in here before this that actually put this stuff in, and we left them because we was having so much problems with them.
Oh, I read the whole.
And a note just for the record too, should we have wanted to, or should we want to, I mean, I'm not assuming anything on anyone, they want to do the full replacement, that's a 30-week lead time anyways.
I think we should maybe look at some sort of long-term capital investment or savings to do that over the next, 5-6 years.
Yeah, frankly, that, it probably sounds worse than the way I intend, but that gives us 5 years to plan for that.
Yep.
Yeah. Versus not $300 grand right now.
Yeah, that's the main thing I wanted, is so it didn't look like we were taking a cheap seat rate out of this.
Right. Absolutely.
No.
But it would be my recommendation
let's,
to proceed with this.
Let's take a break and make the vote afterwards. I want to make 2 phone calls.
Okay.
It has to be done today, that was a big thing.
Okay, yeah, let's take a recess real quick.
Recording in progress.
Okay, we're back from our recess. Again, we're here on discussion on the courthouse HVAC. No decisions were made during the time away.
Only have questions and answers from our subject matter expert. It's me.
But, I mean, I do think this is a worthy thing to do. We're not getting anywhere where we're at right now. That's nothing against anybody or anything, it's just the system is what it is. And that's kind of my concern. And Clerk Painter did give us, we still have not much more, but still sufficient funds in American Rescue Plan Act allotment that we did receive. Perhaps we could consider this project under that fund.
I'll make a motion that we allocate up to $80,000 for the rebuild of the 2 systems. Up to $85,000.
They just know.
Veto.
But get it right away.
Yes.
I mean, get it right away.
Yes.
Please, sir. Thank you.
Okay, that motion-
78,000.
80,000.
80,000 for the variance on the fan motors. Yes. Okay, that motion's on the floor. Any further questions? Any questions from legal counsel? We do have a maintenance and mechanical contract with Train. That as well, you'll find that we do not have any bids or anything. You find that sufficient that we do not need to receive bids?
Correct.
Okay, just want to make sure that's what I had thought.
We found one in the meantime. That's why we did it as an open $80,000 to find it cheaper.
Sure. Well, we probably got to stick with Train on this one. Because they have the contract to do it. Otherwise, we'd have to bid it out. Right, if it was another vendor outside of the contract.
You're in a contract with them now, so. You think you'd find it much cheaper?
We'll try. We'll ask around just to be sure.
Well, I mean, you can always come back next week and undo this, or the next meeting and undo this, if you do find it cheaper.
Unless Rodney tells them we're looking cheaper and they show up tomorrow to fix it.
Yep.
Okay.
Yeah, I just don't want to delay.
Sure.
So if they can come tomorrow and start, that's my thing. As soon as they can get here. And I know
My thing is too, is, you know, they got all the controls on this stuff and everything. They got this already set up in Charleston where they're at, or Roanoke, wherever they want, they could do it at. I don't know if another company comes in here, what's gonna happen with this
Mm.
contract.
You may also violate the contract.
And if we pay for initially or pay for monthly some sort of service that where it's supposed to alarm out, that should, in my mind, that should work. It's,
Yes, I agree with that.
so they can address that while they're in there doing all their magic. And you said it's a 5-year guarantee?
5-year warranty
Warranty,
on
yep.
the entire unit outside,
Gotcha.
not just what they replace.
From the moment it fires up, not when you buy.
Correct.
Yes, sir.
Yeah.
We're not gonna do that again.
Parts were manufactured last year, our warranty still starts this year, right?
That's right.
Every day it turns on.
Yes.
A separate file be formed.
Yes, sir. So that being said, that motion is on the floor. Any questions? Any further comments? Hearing none, all those in favor signify by saying aye.
Aye.
Aye. All those against, the motion does carry. For commissioners' comments, I do want to bring about some letters that have been presented from the West Virginia University Nicholas County Extension Office on behalf of their 4-H program. We have a stack of letters here from multiple of the different campers to the commission. We want to recognize their kindness in sending these to us. And looks like they had a good camp, and they're going to have a good camp, I should say. Did it happen? Did it happen?
Yep.
So they had a good camp. And one says, my favorite part, yeah, you're right. My favorite part about this camp was attending classes. So kids learning something out in nature at the park, and that's always a good thing. So I want to say thank you to Nicholas County's 4-H programs also. That's good.
Is that Chris name?
Amy Walker.
She does a good job.
Amy Walker, yeah, and Director of WVU Extension, Amy Walker. Yes, that's a good point. She does a good job. I would like to request a executive session concerning contractual matters, if we could, please. This is under West Virginia Code 6-9A-4. I do not have any intentions of requesting any kind of action after the executive session, but I guess it's always possible. But if we could have those, please. Have that.
Who's staying?
I would like to request that legal counsel, administrative assistant Neff, and clerk Painter retain the room with this motion. Yes, you too.
Recording
Do we have
stopped.
oh yeah. Go back. I'll come back and sign.
Recording in progress.
Okay, it is 11:12. Do we have a motion to exit executive session?
It's 1:12.
What did I say? 11. That's bad. 1:12 p.m. Do we have a motion to exit executive session pursuant to West Virginia Code 6-9A-4? For the record, no decisions were made during executive session.
So moved.
Motion's on the floor. Is there any further discussion? Any questions? Any objection? All those in favor signify by saying aye.
Aye.
Aye. All those against? Motion does carry. We only have commissioners' comments now. Do we have any comments? I don't think I actually have any today.
Just real quick let's sort of for the essence of time, I know there were some issues that were brought up about the conduct of behavior in the Merchants Walk parking lot the night of the 4th of July. And I know that we're looking at addressing that on what we can do with regards to law enforcement and make sure that that doesn't happen. What we don't want to do is take away the fact that folks want to go up there in those parking lots to celebrate the birth of our country, founding of our country, and let a few people ruin it. So please note that that did not go unnoticed, and it's not going to go unattended or unattended to. That's all it's about.
Except for the trash.
Fights, trash,
Okay.
that's all I got.
We have a motion to adjourn this regularly scheduled meeting of the Nicholas County Commission. Today is Wednesday, July 10th, 2024. It is 1:13 p.m. Motion's on the floor. Is there any further discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Aye. All those against? The motion does carry. Duty stand adjourned.